Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Honorable Chief Justice Kleiner, Justices Busby, Hughes, Denny, Edwards, and Morrison presiding.
Madam Chief Justice, and may it please the court, my name is Caden Hayes from Oklahoma State University. I'm representing the petitioner Charles Adams v. the State of Olympus. In the case of Charles Adams v. the State of Olympus, with the court's permission, the petitioner would like to humbly request 5 minutes for rebuttal.
Respondent, do you have any announcements?
Yes, Your Honor. May I approach the dais? Madam Chief Justice, and may it please the court, my name is Renner Howell from the University of Oklahoma, and I represent the respondent, the State of Olympus.
May I approach the dais?
You may.
Madam Chief Justice, and may it please the court, the petitioner will use the cases of United States v. Lopez, United States v. Morrison, and the National Federation of Independent Businesses versus Sibelius in regards to the first question of if Congress exceeded its authority under the Commerce Clause in enacting the Polio Vaccination Act. The petitioner will use Jacobson v. Massachusetts, Cruzon v. Director, State Department of Health, and Griswold v. Connecticut in regards to the second question of whether the mandatory vaccination order violates the petitioner's right to liberty and privacy protected by the Due Process Clause of the Constitution, and if Jacobson v. Massachusetts should be revisited. Firstly, this court must look towards United States v. Lopez when answering the first question, whether Congress exceeded its authority under the Commerce Clause. In the aforementioned case, the courts established that commerce was fit into one of three distinct categories. First being the use of channels of interstate commerce, second being the instrumentalities of interstate commerce, or persons or things in interstate commerce, and third being activities that have a substantial relation to interstate commerce.
Counselor, which of these three items is relevant today?
Thank you, Your Honor. The item that is relevant today is the third point, being activities that have a substantial relation to the test paired with the substantial effects test. While the economy of the state of Olympus is in recovery from a prior epidemic, it is important to differentiate these two diseases as separate, and that they are both separate diseases as well as have prior conditions of preparations. The fact that the state of Olympus has a 90% vaccination rate of polio. The plausibility of a polio epidemic that is not present in the state of Olympus could only affect 10% of the remaining population.
Counselor, doesn't the fact that 5 significant countries have cases of polio, that people from those countries have had contact with members of the state of Olympus, and that many people are asymptomatic mean that the state needs to take action?
Thank you, Your Honor. While in regards to hotel being part of Atlanta Motel versus United States, the court must consider that even though these individuals are traveling through interstate boundaries, the decision in front of the court was against a non-economic idea, being racial discrimination, whereas in this case, it is in relation to public health. And in that...
Counselor, wasn't that actually a decision relating to economics and commerce, though, because it was a business making decisions about which customers they would serve?
Thank you, Your Honor. It was. Whereas in this case, it is a differentiation of a burden placed on Charles Adams, the petitioner, and individuals in the state and in the aggregate to receive a vaccination, which has no substantial relation to economic commerce.
Also, are you saying that they're talking about a health violation or discrimination here, but there's already 2 ways that they can get out of the vaccination, which is a religious exemption or a health exemption? But here the petitioner doesn't have any of those claims, so how would he be discriminated against?
Thank you, Your Honor. The petitioner is not being discriminated against. It is violating his right to personal privacy and his right to make a medical decision. Discrimination is not a factor in this case. The remaining 10% of the population live in...
Counselor, 10% of the population constitutes millions of Olympians. Why should we leave them behind?
Thank you, Your Honor. The petitioner is not requesting that these individuals be left behind, but that different measures be taken. These individuals stay away from major forms of contact such as public education and thus cannot have a substantial effect on interstate commerce in the aggregate.
Counselor, as the record indicates, currently many states require school children to be vaccinated for polio before they enter public schools. So my question is, are these existing mandates also a violation of the Commerce Clause?
Thank you, Your Honor. These local and state ordinances are not a violation of the Commerce Clause, as the Commerce Clause files under federal power. This disease is well controlled with no reported cases since 1979, and even with the looming threat from 5 countries in their travel to the state, there is little to no proof that this disease sustains or could sustain a substantial disruptive effect on interstate commerce or travel when considering the amount of individuals
Counselor,
vaccinated in the state.
I'm concerned with that assertion because we have to remember that the unvaccinated population is not spread evenly throughout the state. As the record indicates, they're clustered. Quote, a high percentage of unvaccinated adults are employed in farming or food preparation, end quote. It seems like a polio pandemic would possess a unique ability to hamper agriculture in the state, which would undoubtedly influence interstate commerce, would it not?
Thank you, Your Honor. If hampering those individuals through polio, it would substantially affect commerce if spread to these individuals. However, that relies on the activity that it would spread to the individuals, whereas the petitioner is arguing that there is no substantial risk of polio being spread.
But Counselor, the record indicates that 72% of cases are asymptomatic and 25% are flu-like symptoms. So how do we know that polio hasn't already reached the state of awareness?
Thank you, Your Honor. While there is no knowledge of if the disease has been spread to this state, the court can also not surmise that it is spread to the state. Congress has no authority to mandate a vaccination since the disease is well controlled. And the Founding Fathers clearly intended that federal powers are few and defined, while the states are numerous and infinite, and as such, it is best left to the states to decide the matter of vaccination. In regards to the second question, this court must look towards Justice Harlan's test established in Jacobson, Massachusetts, which is the 2 points being necessity of the law in relation to substantial relation to public health, and if this law is beyond all doubt a palpable invasion of rights. Towards the first test, this court must remember that upwards of 90% of the state of Olympus has already been voluntarily vaccinated, and that has reached all plausible goals of vaccination as such. Setting no clear goal and considering the undue burden standard used in Planned Parenthood of Southeastern Pennsylvania v. Casey, in the aforementioned case, it was the opinion of the court that an undue burden can be either too severe or lacks a legitimate rational justification. As with such a goal, the state not having a clear rational goal fails the first test of necessity.
Counselor, this court has held several times that government has legitimate interest or a legitimate goal in protecting life. That's beyond dispute. Never at any point has the court set a definitive number as to how many lives would be legitimate or illegitimate. Even if it is just 10%, as you said, how does the petitioner justify drawing that line?
Thank you, Your Honor. Petitioner justifies drawing the line based off the assumption that these individuals are in rural communities and left in smaller aggregations, that with 90% of the state vaccinated, there is a clear and high consensus that this number was acceptable and has been acceptable since 1979.
Counselor, what level of scrutiny should we apply to this law? Should it be rational basis, intermediate scrutiny, strict scrutiny, or something else?
Thank you. The court should apply strict scrutiny when considering this, as it is dealing with a fundamental right and is not contained in current federal congressional power.
Counselor, it seems to me that the government has already met strict scrutiny, that they are in fact using the least restrictive means, since mask mandates or quarantines would affect all of society's civil liberties, whereas a vaccination mandate only affects a very few people who are unvaccinated and don't have exemptions. So how is the state not meeting the least restrictive means?
Thank you, Your Honor. With meeting a guideline of quarantine, for example, it is petitioner's belief that this would have a substantial effect on public health and would allow strict scrutiny to still apply when considering vaccination due to the fact that in the decision of traveling and restricting travel with the precedent part of land and motel, it was with the court's decision that was effective as it was an economic activity and did not control anything, whereas in this case it is the petitioner's right to make a medical decision and to bodily autonomy that is concerned.
Counselor, if this court decides that rational basis or intermediate scrutiny should be used instead, then would the state win then?
Thank you, Your Honor. The state would not win even under the guidelines of rational basis testing, as it fails to meet a rational basis.
Counselor, you just mentioned bodily autonomy and health decisions, but in cases like Cruzan and Planned Parenthood v. Casey, we drew the line, this court did, when there is the potential for another human life to be harmed. And so, shouldn't we apply that same principle to Adams, who is potentially harming a lot of other people?
Thank you, Your Honor. While the courts did decide in southeastern Pennsylvania v. Casey that it was in the state's interest in the preservation of health, they also decided that it was in the state's interest that it falls just short of any plenary override of individual liberty claims. In that, it is a violation of the petitioner's right to privacy and their right to make medical decisions for themselves when in regards to...
Counselor, does this case really implicate the right to privacy? Planned Parenthood v. Casey, which you cited earlier, concerns the conception of children, which is surrounded by longstanding cultural taboo. Vaccinations, on the other hand, are often administered publicly in front of everyone's peers and are given to all school children. Is this really a case where privacy is of concern?
Thank you, Your Honor. When considering the privacy that the petitioner wishes to express by living alone in his home away from society, it is clear and evident that his will against getting the vaccination is at the forefront of his mind, seeing as he is an individual who wishes to stay away from most means of society. As such,
Counselor, does this court grant anyone privacy over whatever they themselves happen to determine is something that affects their privacy?
thank you, Your Honor.
Counselor, your time has expired.
May I finish answering the question? Your Honor, can you please restate the question?
Counselor, does this court believe that privacy is defined by the individual who is claiming that their right is something protected by privacy, or is it the job of the court to determine what is private and what is not?
Thank you, Your Honor. While no individual has an absolute right to privacy under the Constitution, it is worth mentioning that this right is still valid and present in the petitioner.
Thank you, Madam Chief Justice, and may it please the court. Today, the respondent is respectfully requesting that the court uphold the decision of the lower court and affirm the decision previously made in Jacobson v. Massachusetts. The president's chief pandemic czar has determined that persons with polio have likely already traveled to Olympus and might even already be present in the state. The disease has an R0 of 5 to 7, making it very contagious. Experts have also determined that the vaccine in question is necessary to prevent a pandemic and an economic emergency. The respondent will show that this statute
Counselor,
is in... Yes.
The Polio Vaccination Act of 2021 defines an economic emergency as any time GDP drops by more than 1%. To me, that seems like quite a low bar for the state to establish a legitimate interest. Should this court grant Congress deference anytime the economy dips?
Thank you, Your Honor. The United States economy is normally very stable, and a 1% dip is actually incredibly substantial. In fact, right now, 1% of the GDP is $210 billion. A dip in the GDP of $210 billion is definitely an economic emergency.
Counselor, I don't see how there's a present threat to a dip in the GDP since polio hasn't even been confirmed to be in the state since 1979. So what present threat or what present effect is there on interstate commerce and the GDP?
Thank you, Your Honor. Individuals with polio, due to the asymptomatic nature of the disease, are likely already in the state of Olympus, as has been mentioned by the president's chief pandemic czar. And furthermore, the effects of the SARS-2 pandemic that we've witnessed on commerce can easily be seen from recent history. Polio is both more contagious and more deadly than SARS. And yet, SARS had a clear and substantial effect on interstate commerce. So the clear effect on interstate commerce that the polio pandemic presents is definitely an economic emergency. So the respondent will show that this statute is in Congress's authority under the Commerce Clause by revisiting United States v. Lopez, as well as citing Wickard v. Filburn and Gonzalez v. Reich. Then the respondent will show that the act is not a due process violation, citing Planned Parenthood v. Casey and Washington v. Glucksberg. In Wickard v. Filburn, it was mentioned that specific weight shouldn't be given to nomenclature such as production and indirect to foreclose consideration of the actual effects of the activity in question upon interstate commerce.
Counselor, you used an important word right there, activity, talking about an actual action somebody takes. Whereas today, it seems that Congress is trying to regulate inactivity, which we explicitly said is not allowed in an FIB v. Sebelius. So how does the state defend that regulation?
Yes, thank you, Your Honor. In NFIB v. Sebelius, it was not in the majority opinion that inaction and inaction are different. That was in a concurrent opinion. It was certainly a plurality, but it wasn't the majority opinion, and so the court is not necessarily held to that precedent legally. Furthermore, we have to consider the actual effect of this activity in question, which is getting a vaccination, has on the economy. It is very clear to see that this activity has a substantial effect on interstate commerce, as we have seen in recent history.
Counselor, if you give the Congress power to regulate personal decisions that could aggregately impact interstate commerce, at what point do you draw the line? So would it then be okay for Congress to regulate people's personal spending decisions and what they spend their money on so that they won't have their home foreclosed?
Thank you, Your Honor. That law in question would at least have to pass, at the very least, rational basis test, which that specific law wouldn't, because there's not a clear interest at stake in the government. So no, that law would not even fulfill the most generous test of scrutiny.
Counselor, Sebelius is the only instance that we see that the federal government was trying to regulate health in the name of interstate commerce. A lot of the other cases are state. And there, it did not work with the Obamacare, saying that they're not allowed to have the force of insurance on these providers. So wouldn't having a vaccine be an even larger stretch in that matter? If they can't even control the health of providing a service, why would they provide a vaccine?
Thank you, Your Honor. Once again, in NFIB, the majority opinion was not clear that the individual mandate under that act was not applicable under the Commerce Clause. The majority opinion made no ruling on whether or not the individual mandate was applicable under the Commerce Clause. There was a plurality of the concurrences, though, that even argued that it was under the Commerce Clause. And again, while the court is not legally bound to follow that plurality opinion, they certainly can take it into consideration. Now, in Gonzalez v. Raich, Congress does have the authority over purely local activities, such as getting a vaccination, if they belong to a class of activities with a substantial effect on interstate commerce. So the class of activities here is this spread of, or the prevention of a spread of a global pandemic.
Counselor, in Wickard, we were talking about growing wheat, and in Gonzalez, we're talking about the production of medical marijuana. In both of those instances, it's production, whereas here it's only a health decision, which is quintessentially non-economic. Has the court ever applied the aggregation principle from Wickard in a non-economic case?
Thank you, Your Honor. Once again, if I can quote Wickard, nomenclature such as production and indirect, and the foreclosure of consideration of actual effects of the activity in question upon interstate commerce shouldn't be given particular weight. So
Counselor, while it may be true that the court left some room open in Wickard, is there any case when the court has ever indeed applied the aggregation principle to a non-economic case?
Thank you, Your Honor. At this point in time, no, there is not. The respondent would like to revisit U.S. v. Lopez, and it is the respondent's position that the first prong of that decision is also very relevant here. Congress has the power to regulate the channels of interstate commerce. The petitioner in this case has a river going through his property and uses that river. And rivers are very well-defined channels of interstate commerce.
Counselor, but where exactly do you draw the line here? Although the petitioner might live near a river, does this then give Congress the ability to regulate the decisions of anybody that lives near drains that possibly could drain into a river?
Thank you, Your Honor. The petitioner has the river in his property. It's not simply living near it. So that would be one distinction that could be made. Secondly, rivers are interconnected systems, whereas a drain that simply leads to a river or a pond that might evaporate and rain and fall into a river, these are not...
Counselor, you might have convinced me that rivers have something to do with commerce, but what in the world do they have to do with polio?
Thank you, Your Honor. First of all, polio can spread through water, and so the use of this river is very relevant to the pandemic in this case. Now, the question the court has
Counselor,
to...
today we're not just concerned with the petitioner's actions by himself. We're concerned about the legislation that Congress has passed and then the subsequent executive order. Are all of the individuals who chose not to be vaccinated residing near a river?
Thank you, Your Honor. It is likely that they are not. However, the act is still compliant with Congress's authority under the Commerce Clause, if you consider the effects that the act will actually have on interstate commerce, which is that it will prevent the spread of the disease, which will lead to a pandemic, which will lead to an economic emergency. Next, the respondent would like to show that the act does not also violate the petitioner's due process rights. When considering Jacobson v. Massachusetts, there was a mandate in question in that case as well. And the court ruled that the vaccine mandate did not go so far beyond what was reasonably required for the safety of the public.
Counselor, in Jacobson, the court gave states the police power to enforce compulsory vaccination mandates, and only 11 states at the time had those. In this case, the federal government essentially has the ability to force all 50 states into this vaccination mandate. So why should we grant such a large power to the federal government in this case?
Thank you, Your Honor. The respondent is only using Jacobson to show that vaccine mandates are not a due process violation. The authority of Congress has already been shown in the Commerce Clause. As the court has already ruled that vaccine mandates do not violate the 14th Amendment's due process clause, and so it should respectfully use the same logic applied to the due process clause found in the Fifth Amendment, which is the question at bar today.
Counselor, what level of scrutiny should we apply to this law?
Thank you, Your Honor. It is the respondent's position that the rational basis test is the most appropriate in this situation, as the petitioner's fundamental rights are not at stake. However, even if the court chooses to apply strict scrutiny doctrine, the act would pass that. It is definitely a compelling government interest. This act is narrowly tailored to achieve that goal, and this is the least restrictive means for achieving that interest. Any other means, such as quarantine, would be far more restrictive, especially when it's considered how impossible it is to even know who's contagious with polio in the first place.
Counselor, but in Glucksberg it states that you have to do the specific historical practices before you can move into a different measure. So why not do quarantining like it stated in the case back in the 1940s? Because it was effective. So why was that measure not put out before the mandated vaccine?
Thank you, Your Honor. So it is true that Washington v. Glucksberg does make that point about taking those actions first. However, it is important to know that society has changed since Glucksberg, and it is much more difficult to take those other measures, such as a true and actual and effective quarantine, due to the fact that people, including the petitioner specifically, do get food delivered to them, and this food is prepared and grown by people who are disproportionately not vaccinated for polio, and therefore do have a disproportionately high chance of spreading it to the petitioner, and also due to the petitioner's activities he engages in with other people, which are not none. The petitioner even admits that he is not a complete shut-in, and so he does have the possibility of spreading polio to more innocent people.
Counselor, I'm concerned about some of the implications of this argumentation. With such a seemingly low bar for hypothetical harms to some small number of people, it seems as though Congress could be allowed to then interfere with abortion rights, or we could even see repeats of decisions like Buck v. Bell, which affirmed eugenics and forced sterilization. So how do we justify such a low bar?
Thank you, Your Honor. Regarding the abortion, that has already been decided in KCV Planned Parenthood, so there is judicial precedent for that. However, any other hypothetical acts of Congress will again have to follow rational basis test or a stricter test if they are violating the rights of individuals. Now, KCV Planned Parenthood also mentioned the undue burden placed upon people. Now, in this instance, there is no undue burden of receiving a vaccination, even if it is administered in several doses. There's no undue burden placed upon people, and that case also showed that medical rights are not absolute.
Counselor, at what point would you say a burden is undue?
Thank you, Your Honor. Casey did decide that some of the burdens in the law in question in that case were undue, and some of them were not. So, for example, the requirement that a woman notify her parents before and get their permission before receiving a burden was deemed not to be an undue burden. But getting permission from the father was, flip those two. And clearly here, the getting your parents' permission for a abortion procedure is definitely more of a burden than receiving a vaccination. And so if that is not an undue burden in that law, there's no way that a vaccine mandate can be an undue burden. So it has been shown that the Commerce Clause does give Congress the authority to regulate activities which in aggregate affect interstate commerce, even if they are purely local in nature. It has also been shown that vaccines are not a due process violation, especially when there is no undue burden placed upon them. Therefore, today the respondent is respectfully requesting that the court uphold the decision of the lower court in this instance. Thank you.
While the court must
Counselor,
remember,
the respondent has made a relatively compelling argument using the precedent of Jacobson v. Massachusetts. Is in the opinion of the petitioner that this case should be revisited by the court?
thank you, Your Honor. It is in the opinion of the petitioner that Jacobson v. Massachusetts should be revisited, and that the federal powers should not be that the state power or police power should not be expanded into the federal government, as in United States v. Morrison, it was written that, quote, general power, it was as defined, quote, general power of governing possessed by the states but not by the federal government is police power.
But Counselor, the respondent said that Jacobson is not being cited to justify actions of Congress, but to show that vaccine mandates are not a violation of due process. So should we revisit Jacobson regarding due process?
Thank you, Your Honor. Well, the court could revisit Jacobson under the idea of due process. The court must also remember that Justice Harlan's test is the standard for applying police power. And as such, as the petitioner mentioned in the previous argument, failed the test of necessity, in which to enact police power must at least fail one prong of Justice Harlan's test. Returning to the Commerce Clause, while Congress has no authority to mandate vaccination, since the disease is well controlled in most parts through local and state ordinances, and in the United States v. Morrison, the court ruled that the Violence Against Women Act was a breach of congressional power under the Commerce Clause, as the court said that this power must lie with the states. And Congress does not have the authority to regulate non-economic activities based on conduct in the aggregate.
In Morrison, this court actually refused to create an entire rule based off of aggregation of economic versus non-economic. So are you asking this court to treat the ruling in Morrison as a rule for the court going forward? Or are you asking us to create such a rule or doctrine of not aggregating non-economic activities?
Thank you, Your Honor. The petitioner is only attempting to cite the opinion of the court and prove that there's no precedent of using non-economic activities as a conduct, using the aggregate on non-economic
Counselor,
activities.
given the grave circumstances outlined by the respondent, why shouldn't this be the first time that the court applies non-economic aggregation?
Thank you, Your Honor. Well, the court could apply the aggregation doctrine to economic activities. It still must pass the substantial effects test, proving that this disease has a substantial effect on the economy, not can have a substantial effect on the economy. And as such, since the disease is not presently there, it is hard to surmise that this disease can have a present effect on the
Counselor, isn't it already proven with the SARS-2 pandemic where it was a lot lower of a infection rate and already hurt the economy? So why wouldn't a disease like polio that is extremely infectious not hurt the economy?
Thank you, Your Honor. To reiterate, 90% of the state is already vaccinated.
Counselor, do you know what the amount of the 10% that isn't is the number of citizens?
Thank you, Your Honor. 32 million individuals in the case facts is cited as the individuals that are unvaccinated in this community. Well,
Counselor, looking at the SARS-2 pandemic, 9% of people of the state of Olympus were infected with SARS, and that was still a very large burden on the economy. So assuming that even 9% of the people that are unvaccinated get polio, which is a lot more highly contagious and can be easily spread, that to me sounds like it'd be a very substantial impact on the economy. So how do you respond to that?
thank you, Your Honor. Within regards to vaccination, Your Honor, can you restate the question one more time?
Yeah, so in SARS-2 pandemic, 9% of people received SARS-2, and that still had a very detrimental impact on the economy. So if 10% of people are unvaccinated, polio is even more contagious and more deadly. Would that not even have a worse effect on the economy?
Thank you, Your Honor. While it could have a substantial effect on the economy, it is worth noting that Congress attempted to enact this act under proving that substantial disruptive effect was going to happen on the economy through travel and other means, as cited in the Polio Vaccination Act itself. Finally, in regards, this court must look toward the National Federation of Independent Businesses v. Sebelius, considering the third question of Sebelius, that Congress's authority did not reach the individual mandate to compel citizens to purchase health insurance. If the court were to decide that vaccinations were some form of commerce, it would then, Congress cannot compel individuals to participate in interstate commerce.
Counselor, it seems though that the court today would not be compelling Adams to engage in commerce since he's already engaging in commerce because he's an employee and he makes purchases. Wouldn't it be fine for the courts to say he does have to engage in an activity that substantially affects the commerce he's already engaged in?
Thank you, Your Honor.
Counselor, your time has expired. You may briefly answer the justice's question.
Thank you, Your Honor. While the petitioner does take an active part in a small substantiation of the intrastate market, and to some part, in his own admission, takes part in the interstate market, it is worth noting that courts decided in Jones v. United States that even though Jones's home used natural gas from the state, that natural gas that he purchased was not part of interstate commerce, even though it came from the state of Illinois. Thank you, Your Honor. May I ask for my prayer of relief? The petitioner humbly requests that the court overturn the decision of the lower courts.
The case has been submitted. Thank you all for your time and attention and the professionalism of the audience. We will let you know the results at